My contribution is rather straightforward. After 20 years of international criminal tribunals, do justice systems contribute anything to the resolution of conflict or to the bringing of reconciliation? And I could really sit down after the next sentence, which is, well, not much. And criminal courts, you may recall, when you take a mental step back, have little or no part to play in conflict resolution. And conflicts can, and usually do, coexist with some form of a justice system, even if it's become unable or unwilling to deal with the conflict that's on its doorstep. Most civil wars, most state breakups, as in the Balkans, exist with some kind of justice system. It's just that it didn't operate. But then there are other conflicts, such as our own with Northern Ireland, where the conflict continued, and on both sides of the Irish Sea there were entirely efficient justice systems which did nothing to resolve the conflict. It wasn't their purpose. Crime and punishment systems are not aimed at the prevention of armed conflicts, or even at the prevention of any conflict, save through the very blunt instrument of the deterrence of either the same offender or of other offenders. If we think beyond resolution of conflict itself, which doesn't have to come with resolution, but if we think through it to resolution, it's even clearer that the trial process, the justice system, has probably got nothing to do with reconciliation that is so absolutely central to what we now seek to achieve as we see so many conflicts, many of which are so very dangerous around us. Let's start, however, with a little homegrown message, just to make the point. An experienced judicial system, justice system, our own, if you go onto its website and dig around, you can find something like a mission statement, and it's very moderate in what it claims for a justice system. We work to protect the public and reduce offending, and to provide a more efficient, transparent and responsive criminal justice system for victims and the public. Note, it doesn't say we aim to stop crime. It doesn't say we aim to reconcile, as if anybody would want to reconcile rapist to victim or householder to burglar, or death by reckless driving driver to the bereaved. Interestingly, before I move on to the next little theme, and by way of a slight cul-de-sac, the same Ministry of Justice website is good enough to have on it a paper, a discussion paper by a barrister called Kershen QC, who, I'll come to the thing that you can see at the moment in a minute, who says, actually, we've got to look at a justice system in broader terms. We have to give ourselves the permission to dream of a justice system where healing and changing behavior is central, because he says, on the assumption that we have the capacity to feel for another person, the question is, how can we create a sense of connectedness? And then later on in the paper, there's this very general observation that he makes, having recognized that the probation services in our country have in fact thought beyond the hang 'em and flog 'em of politicians and voters. And he says, well, the victim's needs, he said the best summary of a restorative legal system is that it would be a victim-centered justice system. The victim's needs are for information, validation, vindication, restitution, testimony, safety, and support. Now, this is an idealistic project for a national system where you've got probation services, but the question is, or maybe for us to consider, which of these elements might also apply in the bigger world conflicts with which war crimes tribunals tussle and either succeed or fail. Because, of course, Lawrence Kershen says this is a dream, and trying to sell this on the doorsteps where the Daily Mail has just preceded you in a comfortable country constituency where, as elsewhere, the imagined satisfaction of turning the key on the prison door is a vote winner, however expensive it might be, is a difficult task. So that's why it's a bit of a cul-de-sac. But in fact, the first international criminal courts set up 20 years ago, the new ones that is, they did dream, at least in the beginning. If you go to their founding documents, you can find that they were going to end impunity. Nice idea, unrealistic. In the first report from the Yugoslav tribunal to the United Nations by a much respected, sadly now no longer with us, international lawyer called Antonio CASESSE, he reported dealing with the way that these courts would contribute to the restoration and maintenance of peace. I can't remember quite what I put out there, to the maintenance of peace. And he went on to tell us that the tribunal was conceived, or rather he went on to remind the United Nations that the tribunal was conceived as one of the measures designed gradually to promote the end of armed hostilities, and later he said the tribunal will contribute to the peace process by creating conditions rendering a return to normality less difficult. Yes, in dealing with the value of a court, he says, how could a woman who'd been raped by servicemen from a different ethnic group, or a civilian whose parents or children had been killed in cold blood, quell their desire for vengeance if they knew that the authors of these crimes were left unpunished and allowed to move around freely, possibly in the same town where their appalling actions had been perpetrated? The only civilized alternative to this desire for revenge is to render justice, to conduct a fair trial by a truly independent and impartial tribunal, and to punish those found guilty. If no fair trial is held, feelings of hatred and resentment seething below the surface will, sooner or later, erupt and lead to renewed violence. The role of the tribunal cannot be overemphasized, he followed. Far from being a vehicle for revenge, it is a tool for promoting reconciliation. Why? A truly admirable man, and what he says is well-based, but what is there that's truly reconciliatory about crime and punishment? And I shall be fascinated in the discussion that follows, particularly to hear from Simon on this, because I think this is a really difficult problem. These are worthy sentiments expressed by a really impressive modern lawyer. He went on to say, I can't remember if I got a slide of this. Yes, he says, the establishment of the tribunal, it can apply to any of these courts, shall undoubtedly be regarded as a measure designed to promote peace by meting out justice in a manner conducive to the full establishment of healthy and cooperative relations. And then I think concluded by saying, yes, the tribunal is rather based on the maxim propounded by Hegel that justice be done lest the world should perish. The other tribunal established at the same time, or a year later, Rwanda, for that terrible conflict there, had as part of its founding document, the founding resolution, this assertion. This is the United Nations Security Council speaking in Security Council language. Convinced that in the particular circumstances of Rwanda, the prosecution of persons responsible for serious violations of international humanitarian law would enable this aim to be achieved and would contribute to, remember, I'm looking for the word reconciliation, would contribute to the process of national reconciliation and to the restoration and maintenance of peace, believing that the establishment of an international tribunal for the prosecution of persons responsible for genocide and other above-mentioned violations will contribute to ensure violations are halted. So 20 years ago, people were saying, yes, have trials. They will bring reconciliation as well as resolution of conflict. And although this was well-intentioned and it has various kinds of success, I think one of the questions after 20 years is going to be, were they right? Certainly if you read their subsequent reports, each tribunal reports in very accessible websites once a year, in the subsequent reports you see much less of this and much more of the nuts and bolts of how we're going to get these trials done and where the witnesses are and this, that and the other thing. I just found one other interesting quotation from the middle of the period, June 2000, at one of the discussions on one of the reports by the prosecutor of both the Yugoslavian and Rwanda tribunals. In 2000, this came from the ambassador of Malaysia, to see the political language, whether genuine or not, can't say, but to see how the language was going on, where he says, having reviewed the position of, have I got the right slide? No, here we are. Having reviewed the position of Rwanda, where things were said to be going well, was looking at Yugoslavia, where things were not going quite so well, and he then said, in respect of Kosovo, although events in Kosovo and elsewhere have shown the continuing gap between aspirations and realities, history will record that the international community, through these ad hoc tribunals, has sought to defend humanitarian values and contributed to the restoration and maintenance of peace. Well, the language was still being used, and he went on, the arrest and prosecution of indicted war criminals. The arrest and prosecution of indicted war criminals are an issue not of justice, but one which will contribute substantively, to the process of healing and reconciliation, and to the attainment and consolidation of peace. He then went on to deal with the healing process and ended up by mentioning, and we'll either get to this in my presentation or maybe in the discussion, to the value of what is called outreach, which may have been much more significant for the work done by criminal courts than people ever realized at the time. And I look forward to a discussion, maybe, about that. Unfortunately, despite these optimistic words, the reality was really, in some particular ways, much, much worse. Remember, these courts were created by politicians. Politicians knew very well how to use them. And there are many examples of how these courts have been, they don't have to be forever, but have been vulnerable to manipulation, so that far from resolving conflicts, let alone bringing reconciliation, the court becomes the instrument of war. And the first example is Uganda, where the president of Uganda cleverly referred his own opponents and the conflict they were having with his government to the court. The court needed work, it hadn't got any, it was delighted to have a case. He did not allow the court to investigate what his own government side had done. That has gone on, and that's still the position. It may in due course be changed, but of course, as long as that was happening, whoever was involved in the government had no reason to negotiate, no reason to seek a resolution of the conflict. The reverse. The government had managed to make the court a participant in their conflict. Surprisingly, similar considerations arise in relation to Sudan and Darfur. I declare an interest on behalf of one of the groups involved in Sudan, and it's an interesting and complex, very interesting and complex case. It's sufficient to say that the government's opponents in Sudan, for whom there's plenty of evidence that it's goose and gander, as it were, have managed to get the international community and the court onto their side. The president has now, as Angelina Jolie and Brad Pitt and others wanted, been indicted for genocide. The conflict has become more polarized. The prospects of resolving it by negotiation have become much, much more difficult. And it can be said, and many respected academics do, that this is another conflict that has been manipulated by external forces having their own objectives to serve. I dare say oil has something to do with it, it usually does. The result of which is that resolution of the conflict is more, not less difficult. And just the third example, sadly, is that opening case, really, the case of Rwanda itself, because Rwanda had its own special court, the ad hoc court that was established by the United Nations at the same time as the Yugoslav court, with a very focused jurisdiction. And the court was held in Arusha, not in Rwanda itself, and the court needed work. The judges needed something to do. They had pensions to earn, or at least to get. And what about the Tutsis? The Hutu were being pursued for the terrible massacres, but what about the Tutsis? Plenty of evidence that they needed to be investigated. What happened? I'm afraid that Kagame, who's had a bit of an up and a down in international reputational terms, managed to strong-arm everyone into keeping away from his side. He threatened to shut the court down by non-cooperation if they dared to investigate him. So what has that court done? Well, the truth is that I'm pointing out the difficulties, and I'm not making much of the advantages. The advantages and the benefits of these courts are immense. But when it comes to the simple question of do they necessarily have much to do with the resolution of conflict, I'm afraid the answer's a slightly unhappy one, or at least it may be. Now, the next thing I did, and I shall have to deal with it, I think, rather rapidly, was to have a look through, because we're looking at reconciliation, I have a quick look through the 500 days of hearings of the Milosevic case, 500 odd days, and to search for the word reconciliation. We won't focus on reconciliation, but it was interesting to see how reconciliation was used naturally. When you strip out the reconciliation that had to do with reconciliation of figures, there were about 20 references in 500 days, and about 5 of those are arguably interesting. Veton Surroi, who was an intellectual, owner of a newspaper group, educated in America, had been to a conference in 1997, which comes between the Bosnian War and the Kosovo War. And he was repeating in evidence that at that conference in Halki in Greece, it had been observed then, this was the thinking at that time, that comprehensive democratization of Serbia was the only thing that would bring reconciliation. He said, a fair range of the scope and debate, of course, both the Albanian and Serbian sides had opposite attitudes towards this document, but nevertheless, and he goes on to deal with that. So, for him, a man right in the middle of that particular conflict, it's not the court that's going to bring about reconciliation, it's the process of democratization within the country itself. The next person who used the word reconciliation in a potentially interesting way was Crossland, a UN grandee. And in answering to Milosevic, who was cross-examining him, he spoke of the 200 to 300 to 400 villages that he'd seen burning. And he said, "It's not unnatural that people took revenge, Mr. Milosevic. I'm afraid reconciliation in the Balkans is not a word that's very much known about. Osveta, more Osveta and less, a bit more pomirenje would be a better thing. More reconciliation and less revenge." He saw, harking back perhaps to our last component this afternoon, he saw, as a man with immense knowledge of the area, that what was driving the impossibility of reconciliation was revenge. The third case, the only picture you get from me this afternoon, is a man called Milan Babic. Milan Babic, the dentist from the Knin part of Croatia, had some involvement in the early parts of the Croatian conflict on behalf of the Serbs. He pleaded guilty, advised to do so by his German lawyer, Dr. Müller. He was sentenced, and he gave evidence in the Milosevic case. But to begin with, he gave evidence with his face on the screen pixelated and his voice distorted. But after a time, he asked for the disguise to be lifted. And through his lawyer, Dr. Müller, he gave a number of reasons. That's my colleague on the left, who was dealing with him as witness, and there he is on the right, and I think I've got another picture of him. There he is again. And he asked for the disguise to be lifted for a number of reasons, to do with security and what had been revealed about him already in the press. But he also made it quite plain, in his view, that his telling the truth would serve the purposes of reconciliation. The rest of the story about Babic is, to my mind, quite disturbing. He was a dentist, a devout religious man, a family man. He was clearly contrite. He did everything he could to serve the purposes of any trial or even any truth commission aimed at bringing people together, because he wanted, in his own terms, reconciliation. He was called again in a second trial and booked for a third, and in the second trial was cross-examined aggressively on the basis that he was a traitor, and he hanged himself. And the tribunal, apart from recording his death and having an inquiry to make sure that the penitentiary was let off the hook, shows no interest. But isn't this man as important a figure in the process of dealing with conflict as any? And what do we feel about, what do I feel about, what do you feel about the fact, if my narration of events is accurate, that the people at the tribunal, at the court, really weren't that interested. They wanted him as a weapon, as a tool. And you see, if these courts are to have any purpose, have any effect in the way of conflict resolution or bringing of reconciliation, they've got to have the sorts of understanding that we heard about from Simon. And it's not their job, as I said at the beginning. Courts are not there to bring rapists and victims together. They're there to perform a very valuable function, but much, much more limited. Lord Owen turned up. and he was being cross-examined by Milosevic, and his contribution was to refer to, perfectly properly, to the plans that had been drawn by different peace plans as to how Bosnia was going to be separated out. It's rather sad to note, but we do know these days that there was, I'm afraid, in the West, a great willingness to have the Muslim part of Bosnia kept to the minimum, because people didn't, Western authorities, powers, didn't want a Muslim community in the heart of Europe. You can find that in a book called Clinton's Tapes, which Clinton spoke about very clearly. Never mind, I digress. And the British and the French were described as being full on with that anti-Muslim position at the time. However, the question was, how much territory should the Bosnians get, the Croats get, and the Serbs get? That was the division issue. And so Owen says in lecturing back to Milosevic, dealing with the plans, he says, well, under the European Action Plan, increased the percentage of the territory from 33 to 33.3%. It's probably the best opportunity for peace settlement, which might have been easier to bring reconciliation. So Owen was saying, it's got nothing to do with a court, it's simply to do, and he may be right about this, it's how, if you want to have reconciliation and end of conflict, it's simply whether you get a fair or a happy distribution of territory. Nothing to do with the justice system. General Morillon spoke of what was narrated by another general, General Nambiar from India, who they both, I think, been watching a silent protest march. And Nambiar said to the crowd at some stage, I am an Indian general. I'm here with my head of cabinet, a Pakistani. Then there's also a French general and a German diplomat. We are here to show you that reconciliation is always possible. This was a moving moment, said Morillon, because in response to this speech, a Serb got up and he said, I am a Serb, and next to me I have a Muslim. He's my brother. I don't see how one day we could be confronted against one another. Example didn't work. The odd incidents that were referred to earlier of moments of humanity are well documented. The person who's spraying, there's one in the Yugoslav case of killing people as they come out of a bus and suddenly a small child comes out. He stops. Those examples are well understood and well documented. But here, and this is before Srebrenica, Nambiar is trying to say, look at us. We are multicultural, we are multi-ethnic. One Serb says, I accept your point, but exemplary doesn't work either. And then I think finally, and rather unhappily, there was a defense witness, an academician, historian called Terzic, Slavenko Terzic, and he also used the word reconciliation, but see how he framed it. I consider that if the international community wished to see justice and reconciliation take place, then it must have an equal position and attitude towards all the conflicting parties. I don't see that either the President of Croatia or the President of Bosnia-Herzegovina or any other leaders were indicted, he said, speaking on behalf of Milosevic. So for him, the process of reconciliation's got nothing to do with the court. The court's bad simply because it doesn't treat everybody equally. Now, these are only examples of what you can draw from that particular trial and the language that people were using very naturally. But it does tend to show, does it not, that the somewhat gloomy way I started, and I will, without invading by more than 2 minutes, Tim, the time allocation, I will have something more positive to say in the last 3 minutes. But what we see of the use of language, what we see of the change of language over time of those reporting to the UN, does rather suggest that legal systems have got nothing to do with ending of conflicts, and certainly nothing to do with reconciliation. What might be different in the future? Well, I was very struck recently by reminding myself of the substantial peace movement that existed between the middle of the 19th century and the start of the First World War. Surprising. And people wanted things to be done, including having war crimes tribunals, but they wanted all sorts of things to be done. Do you know what for? To end war. They actually believed that it might be possible to end war. That's why you had the League of Nations and all sorts of other things coming along. Well, now, the First World War would have left them disappointed in more than one way, not just the war itself, but the failure to hang the Kaiser, the failure to have proper war crimes tribunals, and so on and so forth. And that's why you laughed. But, as I said in a lecture here a week ago, if those same people had been able to travel in time to the end of the Second World War, they would have seen that their idealism had now taken shape, or was it somebody else's thinking? First, with the somewhat dodgy tribunals at Nuremberg and Tokyo, with the identification of new categories of criminalizing offense like genocide and crimes against humanity. Then, with the creation of this family of war crimes tribunals that, whether they deal with conflict or not, certainly were an advance. And as I suggested, and persist in suggesting, the idealism, although unsuccessful at the turn of the centuries, of the last century and the century before, may have failed. It must have been a building block for what was to follow, which would, to them, have looked like a success. And what I believe our duty to do now is to identify the new idealism, not simply to look at the institutions that we've got, which will buttress the way ahead if it needs buttressing, and do serve useful purposes. We can discuss those in the discussion period. But what we've really got to work out now, if we want to avoid destroying ourselves in conflicts of the kind that we actually have to contemplate on the Korean Peninsula, what we have to do now is to work out what the new idealism is. And my belief is that the new idealism will not focus on retributive justice. It may have it as a component, but it won't focus on it. The new idealism has to be, coming back again to what I didn't see this session before you did. I didn't know what was going to be said. But focusing on knowledge and information, because it is, I think, it's easy enough to argue, maximizing knowledge and information about what happens in conflict that will enable us as citizens of the world to find better mechanisms in the future to control, limit, not to end, I suspect, but to control and limit conflict, and may, however slowly, increase the prospects of achieving some reconciliation in these conflicts. Thank you.